Good morning, Caroline Zilani, karibu sana.
Thank you, Commissioner.
Good morning, Charity Kisotu, Commissioner, welcome.
Thank you, Commissioner.
Good morning, Omwanza Ombati, karibu.
Thank you, Commissioner.
Good morning, Jokindum.
Thank you, my lady.
Good morning, Council. Anton Mrima, karibu sana.
Thank you, my lord.
Good morning, Wakili Fatuma Sichale, karibu sana.
Thank you, my lady.
Good morning.
Morning.
I'm Oluwande Evelyn. You are welcome.
Thank you, Commissioner.
Good morning, Dorcas Odur, Senior Counsel and Attorney General.
Thank you, Honorable AG.
Winfrida Mokaya, Secretary, you're welcome.
Thank you, Secretary.
Yes, thank you, Commissioners, for that introduction. This is Mr. Martin Otieno Obuo.
Yes, my lady.
If you could start by telling us your county and ethnicity.
My county is Kisumu, and I'm Luo.
Very well. We want you to be comfortable where you are seated. The water in front of you is yours. So we will begin this interview, which we want to make conversational so that we can get the best out of you. We've read your CV and all the material that you sent us, but we want to hear from you in a summarized way. What makes you stand out to be nominated out of the 100 candidates we have in front of us? What unique experiences you want to bring to the High Court, skills or achievements that define you and distinguish you from the others? You know the challenges we are facing in the High Court.
Yes.
How are you going to help us deal with those challenges? We had a stakeholder engagement before we started this exercise, and the feedback from the stakeholders is that we should look for heavy lifters, people who can work hard, men and women of integrity and impeccable probity, moral probity. So we want to hear from you how you fit in that as well. You have 5 minutes.
Yes, thank you, my lady and Honorable Commissioners. I'm Martin Otieno Obuo, an advocate now of 25 years experience. I think I'll be this April 12th. I'll have done 25 years of experience. This is gleaned from both public and private sectors. I've been at the AG's office, then it was prosecutions was under the AG. So I've been a prosecutor, then I've been an evidence analyst with the Ethics and Anti-Corruption Commission. Before that, it was the Kenya Anti-Corruption Commission. I have been a principal legal officer at IPOA, and I've also been in private, where I am now, with the firm of Soit and Associates and partner and a consultant. I've handled cases as in private practice on behalf of state corporations and also multinational companies, both at the High Court and the Court of Appeal. And if I may say, just few of my achievements. I've handled sensitive cases, criminal, at the Attorney General when I joined as a young advocate. And I've also helped in analyzing complex corruption cases at the ESCC. And I must say that when I joined, there was a huge backlog of cases that were awaiting consent from the DPP. So we managed, actually, to clear the backlog. And the DPP was able to make decisions on those cases. At IPOA, I also found a backlog because they cannot prosecute, they, after investigating issues concerning police misconduct, they have to forward these files to the DPP who prosecutes. And in that regard, I also helped clear the backlog. So I'm hardworking. If I may just say three things, what I perceive to be an ideal judge and how I fit in. The first of all is professional competence or expertise, knowledge of the law, and ability to appreciate the facts and apply the law on the facts. And I've done that throughout my professional life. To communicate properly through judgment, I'm a good communicator. I so believe my writing skills are good. A judgment ought to communicate, my lady and honorable commissioners. It's the only way a judge communicates, through the judgment. So it must be well reasoned. You must indicate that you appreciate the facts, you've understood the facts, you've understood what the witnesses have said, you've analyzed it, you've delineated the issues, and then you've applied the law to the facts and you've given reasons for your decisions. So I'm competent. I believe I'm competent. Secondly, a judge must be of judicial temperament. I believe I am of judicial temperament. I'm emotionally balanced. I can say that I'm patient. And thirdly, a judge must be of integrity. These are the three broad qualities I think a judge must exhibit. So in terms of integrity, I've worked in accountability institutions, like I've said, at the AG, I was a prosecutor, then an evidence analyst at the Ethics and Corporation Commission, and of course at the IPOA, where we could look into police misconduct. I have no case pending against me, so I believe I'm a person of integrity.
We'll now
Yes.
go to the next area, Commissioner Mwanza.
Thank you, Chief Justice. Council, good morning again.
Morning, Commissioner.
In a case of Richardson versus Mellish, it's an 1824 case. Public policy was defined as an unruly horse.
Yes.
That when you get astride, you never know where it will carry you. Now, public policy is one of the considerations that are used to set aside an arbitral award under Section 35 of the Arbitration Act. Now, in the case of Glencore Grain Limited versus TSS, the court said as follows: that a contract or an arbitral award will be against the public policy of Kenya, in my view, if it is immoral or illegal, or that it could violate in clearly unacceptable manner basic legal or moral principles or the values of the Kenyan society. So my question is, what are these moral principles or values of the Kenyan society that the court can use to set aside an arbitral award? And how does a judge arrive at a conclusion that something is against the moral or principal values in a Kenyan society?
Thank you, Honorable Commissioner. Morality is wide. It depends on how a society views itself. There are some generally held principles in a society that the society frowns upon, a community frowns upon, like, let me say, prostitution can be said to be moral, though not illegal. So if something is immoral but not illegal, why then will the court base its decision on that to void an arbitral award? The court, law and morality, like Fuller said, sometimes they go together. That's why it's immoral is to prostitution is immoral, but not illegal, but living off the earnings of prostitution is illegal, or touting as a prostitute. So it's a moral code of a society, let me say that, unacceptable, where you cannot go beneath. There's a level.
Then doesn't that in that sense, then doesn't public policy give give in to a judge's subjective views about an issue than something that is objective, that is written in the law? Because when it says, because from this case it says it's either immoral or illegal or against the principle or values of the Kenyan society. So then does that mean that then a judge becomes the judge or the paragon of virtue or morality and what the values of the Kenyan system is, and then uses that as a basis to vitiate or to set aside an arbitration, an arbitral award?
Yes, there is that danger, Honorable Commissioner, where a judge can conflate morality and law and decide to subject that to his own subjective rather than objective cause. But we have to live with that as society. For instance, if I deceive you, if I in an arbitration award I use deception, which is not at the level of something illegal, the arbitrator cannot close his eyes to that. He can use that to deny the award, or the High Court can use that to set aside the award because it's been procured through deception, though not rising to the level of illegality, but it's immoral. We've accepted, all of us. But I agree with you that the judge's outlook or perception can come into play, what he perceives to be moral.
Perhaps even their own values.
Yes, perhaps even their own values.
So then how does then a judge guard against that, so that they always maintain the core value of judging, which is impartiality and objectivity?
Yes, a judge has to rise above that and look at the law, not necessarily the morality that underlies that law. And how can I put it? Impartiality doesn't necessarily mean that a judge, because a judge is a human being with the I think it's Justice Odunga who said that we don't stop being human beings when we become judges. So a judge can perceive things that will shock the conscience of society. Let me put it that way. Yes. So as you said, public policy is an unruly horse. So and a horse, when it bolts, it goes whichever. So there's difficulty in circumscribing morality. And
so what will be your view if an arbitral award was challenged, if you are sitting as a judge, on the basis of public policy and more so on the values and moral principles of the Kenyan society?
If I have to, I'll look at the Kenyan society. What does it rise to the level where it will shock the conscience of a society? Then but I will not look at it subjectively. I'll endeavor to gauge if it rises to that level where it can shock, where in all good conscience I cannot accept that. Yes.
Okay.
Yes.
Thank you.
Thank you.
Thank you, Honorable CJ. Wakili, I appreciate that you worked in quite a number of places.
Yes, my lady.
Just one or two questions.
Yes.
Before the enactment of the Prevention of Corruption Act in 1997 and subsequently the Anti-Corruption and Economic Crimes Act, an offense akin to corruption was in the Penal Code.
Yes.
actually the offense of bribery. And whenever an accused person was taken to court,
Yes.
it was mandatory that the consent of the AG then be obtained before prosecution.
Yes.
Why do you think this was the case?
Yes, I'm aware of that, my lady. The Prevention of Corruption Act had a provision for consent. I think the nature of the offense and the political climate, if I may say so, at that moment demanded that some gatekeeping be done, because bribery involves majorly the political class. So I think it was a way of the political class making sure that they had the control. They could gatekeep who gets charged with the offense of bribery. But I'm just
You're hazarding a guess.
yeah, I'm hazarding a guess.
I think
my lady.
myself it was because of
Yes.
the very serious nature of the offense.
Of the offense. Okay. Yeah. I'm
You know,
guided.
almost akin to murder.
Yes.
I'm not saying I'm right,
Yes.
but that's what I've always thought. Now, again, you say that when you joined the Anti-Corruption Commission, you found that there was a backlog
Yes.
as regards the matters that were pending,
Yes.
awaiting the consent of the DPP
Yes.
under the provisions of Section 35 of ASECA.
35 over seconds.
Now, how has this section been dealt with in view of corruption offenses where one is arrested on the spot with bribe money that at the commission they are referred to as sting operations?
Yes. They have to, the Anti-Corruption Commission has to get consent before it's, and then after that, the practice.
You understand what a sting operation is?
Yes, yes, I do understand.
What is a sting operation?
Sting operation, my lady, is where there is a solicitation of a crime, and then ordinarily the practice will be the anti-corruption officers will pose as a person who needs some service after receiving a complaint that there was some solicitation. So the complainant, no, I'll take that. The complainant reports to the Anti-Corruption Commission that there's an officer who is soliciting for a bribe, and then he is, of course, given the gadgets, and he goes, and that solicitation is captured on tape, and then treated money maybe is given to the suspect, and in the process then the Anti-Corruption Commission officers who are waiting, lying in wait, they come in and arrest.
So
and arrest the suspect.
Someone is caught red-handed.
Yes, red-handed.
And the question I was asking, in view of Section 35 of ASECA,
yes,
here you've caught somebody red-handed.
yes,
You still must get, so you've caught them red-handed, you're processing them to go to court.
yes,
Yet you must get the consent of the DPP.
yes.
My question was,
Yes.
how has this been resolved?
A synopsis is nowadays sent to the DPP, just a short summary of what has happened, asking for the DPP's consent
What have the courts said about this?
to. Yeah, there was the courts have not been very receptive to that, but I think the consent, after just looking at the evidence presented by the commission, the DPP can give consent, and then later he receives the whole file. And
So what do we do with somebody that we've caught red-handed?
they're still charged, in my opinion. They're still taken to court.
But
and
we
then
must get consent from the DPP.
Yes, the DPP gives consent before
When
they're
does he
charged.
give consent?
Oh, before the person is arraigned in court.
Are you aware of any decision that addressed this issue?
Not that I can remember, but there have been decisions, my lady.
All right, thank you.
Thank you,
Thank-
my lady. Thank you.
Okay. Thank you so much, Honorable CJ and Wakili once again. Welcome.
Thank you.
We go to Article 261 of the Constitution, as well as the 5th schedule. This is the article which provides for post-2010 legislation. And if I may just generally take you through, I know you know it. It addresses the question as to what happens, within what timelines are registrations, are legislation supposed to be undertaken, and what happens in default. And the procedure has been, if there is no compliance by National Assembly, the National Assembly can extend time.
Yes.
And if within that extension, 1 year extension, nothing happens, a petition can be filed before the High Court.
Yes.
And High Court may direct the National Assembly to undertake the legislation. And if nothing happens, then the CJ has the sole duty of advising the President to dissolve Parliament.
Yes.
That's the general provision under 261 Schedule 5. Now, on the gender parity case, you
Yes.
must be very much aware of this case.
Yes, my lord.
Looking at that case, vis-a-vis our current constitutional dispensation, on the aspect of elections, which elections are mostly based on the universal suffrage, whereby you go to the field, you fight it out there,
Yes.
you get elected into Parliament, and of course with a few positions which are reserved for, like the women, as in women rep. The rest you fight it out there.
Yes.
Now, where we are now in that matter is there is an advice from the Honorable CJ to the President on the solution.
Yes.
Of course, there is a case in court. I don't think whether it's been determined, but let's put that case aside.
Yes.
If that case is not there, and looking at the structure, our constitutional structure, and the issue of the universal suffrage of elections, do you think that dissolving Parliament will assist in achieving the gender parity as contemplated?
Thank you, my lord. I don't think dissolving Parliament will be the panacea, simply because there is, as you said, correctly pointed out, that universal suffrage elections are by universal suffrage, and you cannot interfere with someone's right to vote in a person of their choice. And so there's a conundrum, my lord, in the sense that there is that provision of the law, and Chief Justice Emeritus, I think, wrote to the President calling upon him to dissolve Parliament because of that. But then I think our constitution should not be a suicide pact, in that it will be very detrimental to the society if Parliament were to be dissolved on account of that. So I don't know what can happen. I don't know if there's some legal mechanisms that can be put in place to address that, and to make sure that compliance maybe is graduated to, so that we get to our neighbor, I think Rwanda and even Uganda. They have done quite well on the gender front in terms of representation, but it's a conundrum, my lord.
Now, if you look at the county assemblies,
Yes.
the composition of the county assemblies,
Yes.
you realize that this problem which you're facing in Parliament is not replicated in the county assemblies.
Yes.
What do you think? How do you think that situation was taken care of down there? And I think within the county assemblies, the gender parity, I think it's relatively within the constitutional limits.
Yes, it is.
Yes. How different is it in Parliament and in the county assemblies?
I think women are disadvantaged at consensus level in terms of because of the way the society has treated women in terms of the political mobilization, and so they find it easy to mobilize people on the grassroots. Very good at the grassroots, so they can have the numbers at the grassroots. But when it comes to MP, because you require a lot of resources, I think, and the violent nature of our politics, so you'll find that the numbers are not as good as at the ward level.
Okay, you will note that in the county assemblies,
yes,
we have the party lists. I think even in the other case we also have party lists.
yes,
But the party lists in the county assemblies insist on
yes,
on gender. I think that is one way
yes,
the county assemblies have managed to attain the gender parity. You think that should be thought for parliament as well?
yes, that should be thoughtful. But I don't know how many members can be nominated to show up the numbers, because then there's the limitation of the number of nominees that any political party can nominate. I think there's a ceiling, so it's a.
So if I get you right,
Yes.
you may be thinking that this is a way which calls for for us to relook at the constitution.
Yes,
Maybe in terms of amending it and all that.
yes, my lord, and also to make it easier for women to participate.
Yes.
Yes, to deliberately put in place measures that make the political environment conducive the participation of women.
Okay. Lastly,
Yes.
let's move away from the gender parity case. Let's say the non-compliance has been on any other case,
Yes.
and the advice has been placed before the president,
Yes.
and the president declines to act. According to the BBI case,
Yes.
you cannot take out proceedings against the head of state, that is the president.
Yes.
What you can do
Yes.
is you can get down to the legal advisor, who is the Honorable Attorney General.
Yes.
Now, in this case,
Yes.
let's just put a scenario. In this case, you are saying
Yes.
the president has declined
Yes.
to comply with an advice which the Constitution says shall
Yes.
comply,
Yes.
and the law says you cannot touch that person who has failed to comply.
Yes.
Go to
Yes.
the AG.
The AG.
You think any contempt proceedings will succeed against the AG?
No, I cannot proceed because these are the actions of the president. The AG, being the principal legal advisor, can only advise the president, but the decision vests in the president, and that's why you look even when the appointment of judges, when the former president refused, there was nothing much could be done in that. That's our reality in terms of
How
real
things
politics.
are on
Yes.
the ground.
Yes, yes.
Okay, thank you.
Yes.
I wish you the very best.
Thank you very much, my lord.
Good morning again.
Good morning, Honorable Attorney General.
Kindly define for us the legal principle of adverse possession, identify legal underpinnings in our jurisdiction, and explain to us 5 requirements to warrant a claim.
Thank you, Honorable Attorney General. Adverse possession is where you, without the permission of the landowner, you trespass, I may say so, and stay there for a period of 12 years, uninterrupted 12 years, and so you can go to court through originating summons and lay claim to that to the land. So you must prove that there was no permission. The from the landowner, there was no consent. He didn't allow you to stay there, so there was no permission, there was no consent, there was no stealth, in that you did not go behind their back. They knew that you are there. You did not use force, you did not use compulsion to acquire the land. For instance, maybe like post-election violence, when you get that land, when there's such kind of violence, then adverse possession cannot stand because you used force to occupy the land. So no stealth and no permission and no secrecy are important when it comes to...
I'm hearing properly.
Or there should be no permission,
Yes.
no stealth, in terms of it should be open that you're occupying that land, and there should be no force. Yes, I think these are the major. You have not used any force, you've not used stealth, you've done it openly, and the landowner did not permit you. If they permitted you, then it cannot arise.
What about the duration?
12 years, Honorable Attorney General. You must have uninterrupted, stayed there uninterrupted for 12 years.
So which legal provisions do we have to support this?
It's a common law, some, but now again it's recognized under the Land Act, I presume. Yes. It's a common.
You are fading.
It's a common law principle, Honorable Attorney General.
Under which act, legislation?
The Land Act, yes.
You're done. Good. It's my turn. It's your turn. Okay, karibu.
Good morning once again, Council.
Good morning, Honorable Commissioner.
You want to take some break or are you good? Water break? Yeah, I see you.
No,
your
I'm
hand
good.
is heading there.
I'm good. I've just taken some. Yes.
Great.
Yes.
Council, I've seen your submissions. You shared with us submissions in constitutional petition, judicial review,
Yes.
commercial, and ELC matter. They reflect strong doctrinal competence, structured reasoning, and consistent clarity in issue identification. You are able to link statutory and constitutional provisions to the facts, and you engage with case law in a sound manner. So I commend you for that.
Thank you, Commissioner.
Kindly share 3 key principles under the bungalow principles of judicial conduct.
Yes, thank you, Commissioner. I can recall integrity, impartiality, judicial temperament.
I'll add independence.
Independence,
What is
yes.
your understanding on judges' decisional independence?
The decisional independence, Honorable Commissioner, stipulates that judges cannot be influenced by external factors when arriving at their decision. The decision-making process is intrinsic, is upon the judge applying his mind to the law and the facts to arrive at a decision without any influence.
Okay. And how do you then distinguish
Yes.
between an appealable judicial error
Yes.
and conduct that may warrant a judge's or magistrate conduct that may amount to misconduct? What principle should guide the distinction?
The principle, I think, should be what a reasonable judge, ordinary skilled judge, the reasonable test can be applied.
Oh, yes, maybe you can
Yes.
give further details on the reasonable test.
Yes. you look at a judge reasonable skill and training, and you juxtapose that with the decision. If there's a huge disconnect, then there's a problem. For instance, if I am a judge in a high court, then I deliberately take a matter that is maybe land and decide on it, assume jurisdiction that I don't have, then there'll be a problem there. But if I make a mistake that any other judge will make in the ordinary course of his or her duty as a judge, then that is appealable, and the judge should not be penalized. But if it's egregious, if the infraction is so egregious as to take you out of the confines of competence or suitability, then that will become either incompetence or gross misconduct.
Okay, how about
Yes.
if a judge ignores case law from superior courts, from Court of Appeal and Supreme Court? Can that also amount to misconduct?
It can amount to misconduct because the Constitution binds the judge, that is bound by decisions of superior courts. But then if he can distinguish, then he will be okay. It will be okay. If he can distinguish, he can explain that I disagreed with that because of 1, 2, and 3, or 4. So it's the thought process of the judge, whether it's reasonable, whether it's objective, whether you'll expect that of a judge of his skill and training.
So a judge can still explain and still depart?
Yes, he can explain.
Provided a judge explains, he can depart. Is that what you're trying to say?
Yes, he can depart
if a decision of a superior court.
Yes, he can distinguish. He can distinguish that, saying maybe the circumstances were a bit different, or the law had changed, or any of that. Yes.
Thank you.
Yes.
All the best. Thank you.
Thank you, Honorable Commissioner.
Yes. What do you understand by the term free speech?
Thank you, my lady. Free speech is to be able to express yourself without being unnecessarily constrained by the society or for reasons maybe political, economic, or even faith persuasions. You're able to state.
How would you
your mind.
distinguish free speech from hate speech?
Now, hate speech invites others to hate a particular person, so it's not allowed. It's a limitation on free speech. It brings or can cause violence or war or ethnic cleansing, so it's not free speech. There are limitations.
So if I come and tell you
Yes,
that let us hate Commissioner Mwanza, is that hate speech?
No.
Why?
You've expressed your opinion, that is free speech. But if you come and say, Commissioner here needs to be ostracized or lynched, or then that becomes hate speech. He and his people are, maybe you now characterize his people or his community, or then it becomes hate speech, my lady.
Okay.
But merely saying that you hate him, that's your opinion.
So do you have an example, even globally,
Yes.
of where hate speech has been found? Or you can define what you're saying.
Yes.
You can say in this country, this happened, this was hate speech.
Yes. In Rwanda, there was this radio station, I forget the name, that you refer to others as cockroaches, and that should be exterminated. And the predominant ethnic group went and in fact did just that.
Okay.
So that, yes, that can be.
Is there a local example you can give us?
A local, maybe we've heard of Madoadoa, or we've heard of people who should be uprooted, and I think that should be hate speech.
Those descriptions were contained in a report by, are you aware of which report?
Yes, there was the Wakis Commission. I think I can only...
and the Kriegler.
Yes, and the Kriegler Commission.
Okay.
Yes.
Thank you very much.
Thank you, my lady.
Yes, thank you, my lady. It's now afternoon. Good afternoon.
Good afternoon, Honorable Commissioner.
Yes, you agree with me that independence goes hand in hand with accountability?
Yes, my lady. Yes, Your Honor.
Yes. If you're successful and you become a judge, how will you ensure you remain accountable in the discharge of your function?
Yes, in fact, as I said, accountability, a judge must be accountable. And one of the reasons, and the major reason, is to give decisions for your findings. You must back your findings, so anybody looking at your decisions must see properly how you arrived at the decision. That is being accountable to the public and accountable also to the profession. And so as a judge, individually, accountability involves giving decisions and also living within the acceptable conduct of a judge. What is acceptable of a judge? In the code of conduct, you must follow it. Judicial service conduct, you must.
So you stay true to the
yes.
code of conduct.
Yes.
You give reasons for your decisions.
Yes, for your decision.
Any other way?
Another way, as an individual judge, I can say to be a person of integrity, to not to be
that's
in circumstances where
code of conduct.
That's code of conduct.
It's also about filing accurate returns for the work that you do on a day-to-day basis.
Yes.
Now, the JSC is mandated to ensure that the judiciary remains accountable, and also you, as a member of the judiciary, once you're a judge, also remains accountable.
Yes.
In your view, do you think that mandate allows the JSC to probe the accuracy or the validity or the veracity of your decisions?
Honorable Commissioner, it's a dicey situation because you have decisional independence in that you must, when you apply your mind to the facts and you apply the law, that should be it. Anyone who is aggrieved should either seek review or appeal.
Mm-hmm.
But in circumstances where this is so egregious, as I've said, then the JSC should be able to come in and ask you to explain.
Okay.
Yes.
So there is an extent to which the JSC should be able to come in and look into your decision and decide whether there is impropriety in your decision?
Yes.
Okay.
Yes.
Thank you. I wish you well. Thank you, my lady.
Thank you, Commissioner. Yes.
Thank you, Honorable Chair. And Wakili, I have one question for you.
Yes, Commissioner.
Now, how will you balance the constitutional imperative for expeditious justice with limited judicial and administrative resources?
Expeditious disposal of cases vis-a-vis the limited resources. Yes, the resources will always be limited, Honorable Commissioner. So we have to work with the resources we have. We have to make sure that cases are disposed of expeditiously in terms of a good and efficacious case management will help one to dispose of cases, to narrow down the issues, to rein in the litigants and the advocates appearing before you so that they don't waste time, they don't seek adjournments, they don't delay proceedings unnecessarily. So you'll use that. These measures don't really require resources. It's just your case management strategy that will then speed up cases. And like the law provides, there should be no adjournment, but we still have that issue. The reality sometimes strikes, and that rulings and judgments should be delivered 6 days after. So you confine yourself to these legal strictures, and that don't really require a lot of resources, Honorable Commissioner.
And how can technology be deployed to enhance efficiency without excluding justice to those who cannot access?
Yes, Honorable Commissioner, technology is very important. in terms of like nowadays, person doesn't need to travel to incur expenses. You can have virtual hearing. You can file your matter virtually. You don't need to go to the registry. You can follow up cases on CTS. You don't need to go to. So it's assisted. Technology has assisted the dispensation of justice in terms of even reporting, law reporting. Nowadays, very fast ruling or judgment is delivered, and immediately we can access it. So there's a way that technology has really advanced the course of justice.
So what about those who cannot access?
Those who cannot access, yes, are disadvantaged, especially in regions where the network is not very good. That's a real challenge. You find that the call sometimes hangs or drops. So, and there are people who don't know how to utilize that, so they are disadvantaged. So the panacea here will be to increase network, but that is not in the hands of the judiciary. But they can talk to stakeholders like providers of these services to increase networks and also to make these services affordable to the majority of our people. Like, let's say there's public Wi-Fi, there's place where government can roll out public internet services. It can help in reaching those people who find it very difficult to access justice or courts.
Okay.
Yes.
Thank you. I wish you all the best.
Thank you, Honorable Commissioner.
Thank you, Honorable CJ. Council,
Yeah.
what is your understanding of mentorship?
Thank you, Honorable Commissioner. Mentorship is basically taking people under your wings and guiding them professionally, teaching them the ropes, teaching them how to conduct yourself. Yes, guidance is about guiding people.
Okay.
Yeah, guiding. Follow me as I follow, as Paul said. I think one of the script. Follow me as I follow Christ. So you're guiding people.
Okay.
Yes, yes.
What are some of the benefits in any organization?
The benefit is there's a culture buy-in when you mentor them, you teach them this is the culture of the institution, this is the way things are done. So they buy into the culture of the institution, and this helps in terms of unity, in terms of delivery of services, when they know that in this organization we reward diligence and we frown upon maybe laziness. We reward excellence, we frown upon slothfulness. So it helps improve performance in any organization.
Okay.
Yes, yes.
What do you do when you're faced with multiple tasks with conflicting deadlines?
Yes, Honorable Commissioner, you prioritize. You put these urgent, it's not very urgent, and then you handle them in that order, because you can be overwhelmed if you want to do them at the same time. So you prioritize, this is important, this is urgent, and this is not so urgent or not so very important.
So time management and prioritization.
Yes.
Any other?
Yes.
Any other?
You delegate too. You delegate some if you are able to delegate.
As a
you
judge,
can
what
delegate.
would you
As a judge,
delegate?
you cannot delegate. You can delegate research, but you cannot delegate writing of rulings and judgments. You have to do it yourself.
Okay.
But you can delegate people to research for you, and yeah.
Other than
as you
research, is
guide
there
it.
anything else you can delegate as a judge?
Maybe administrative work.
Okay.
Administrative, yes.
All right.
Yeah.
Thank you, and I wish you well.
Thank you, Honorable Commissioner.
Yes. What, in your view, is the role of the judiciary in socio-economic development?
Thank you, Vice Chair. The role of judiciary in socio-economic development is to ensures social justice is one of the national values. To cultivate social harmony, citizens should know that when they come to court, they should be able to resolve their disputes peacefully without resort to violence. So it helps in fostering social harmony. Economically, it helps you when you solve economic disputes. It helps in the economic well-being of society. People are able to enter into contracts, property rights are protected, they are observed, and the society is able to do well economically. Nobody wants to invest in a country where there's no rule of law. The property rights are not respected. So the judiciary comes in to solve these problems expeditiously and declare rights, and the business community is able to now work in a predictable environment, and this helps a country to grow economically. I think that's.
Thank you, Oshua.
Thank you, Vice Chair.
Thank you, Commissioners and Council. This, I think, brings us to the end of this interaction with you. But before we release a candidate, we always give them a chance also to engage us.
Yes. Yes. Let me just say, I want to appreciate you. Thank you for inviting me. And I also want to point out one of the policies I think you did inaugurate recently, dealing with sexual harassment policy and also gender inclusion.
Yes.
I think you set a very good standard for the other arms of government.
Yeah.
As somebody who has suffered in the past because of my physiology, I appreciate.
Notice you
yes,
have disclosed you are a person with disability.
Yes, I've been. Yes, so I appreciate the fact that you will think about that, and other arms of government should take note of that.
Yes.
Thank you so much, Chair and Honorable Commissioners.
Okay, thank you. On behalf of the Commissioners and the entire Commission, we wish you success.
Thank you.
We will get in touch with you when we complete the exercise.
Yes.
It's a difficult one because we have so many applicants.
Yes.
So we always encourage every candidate to keep up the good work that they are doing, wherever your calling is. So we wish you well.
Thank you so much,
yes,
CJ.
You are released.
Thank you.
You can take the writing pad, your water, and somebody will show you where you can have some cup of tea.
Okay, thank you so much.
Yes.